Everybody, this is James with Win-Win Home Buyers, and I've got an exciting guest for us today. We've got Frank Hinton here. He's an oil and gas attorney here in Oklahoma City, and I'm excited to have him on to talk about mineral rights. So Frank, we'll toss it over to you.
Okay. I went to law school at OU about 10 years ago or so, a little over that now. Just kind of found property to be one of the more interesting classes I took my first year, and so I thought I'd kind of maybe aim toward that as a way to go. And then about a year and a half in, I got a clerkship here at Elias, Brooks, Brown and Nelson doing oil and gas title work, and so I've basically been here ever since. That's about it.
Awesome. Well, like I said, we're excited to have Frank here today because there's some confusion as to how to deal with mineral rights when it comes along with a property. And though it doesn't happen all the time, it is something that we've dealt with, and it's something that I've personally dealt with. And I actually reached out to Frank and worked with him on the project, and it allowed me to be able to actually close the deal. And so what I wanted to do was get Frank in here to talk a little bit about mineral rights and really how you're going to approach it if you have a house that also has mineral rights attached to it, and really kind of how you can calculate what those mineral rights are worth. So Frank, I'll toss it over to you, and we can just jump right into mineral rights. So as a business, or as someone who is selling a house and they've got mineral rights on that house, how do they actually find out if they're the one who owns the mineral rights or if somebody else has it?
That's a good question. To start off, we'll say that if you live in a city, if you live on a lot that's lot and block style house, then there's a good chance that you don't own any mineral rights. That's unfortunate news for most people, is most of the time when they took that piece of land and they cut it up into lots and blocks, what they did is they severed the mineral rights and sold it off to a third party, or maybe kept it themselves and then sold all the lots and blocks without mineral rights. So most people who own a house in a city probably don't necessarily own their mineral rights. That's not to say it doesn't happen. It frequently happens that they sell those off and forget to reserve the mineral rights or don't care about it. And so we deal with that pretty regularly, but I'd say the majority of the time, 75% plus of the time, there are no mineral rights under that land. But to go back to your question about how do we know, well, we do what we do, which is called an oil and gas title exam. And we do a title opinion for usually on a drill site basis. So that's going to be, roughly a square mile usually. And we take all the land in that square mile and we do a title opinion for each separate tract. And we go back into the county records, go back from inception, which is when the government patented the land out, and search forward and look for mineral conveyances or mineral reservations where an owner would have severed those and sold them off to a third party or kept them themselves. And we determine who owns those mineral rights.
I see. So as the developers are purchasing up the big lots of land, they're most of the time separating the mineral rights from the actual development part of it, and then just either selling them, on the side or keeping them.
Exactly. They don't necessarily. They're sort of two different worlds. There are real estate developers and real estate investors, and then there are oil and gas developers and oil and gas investors. And so most of the time it makes economic sense for them to just, sever the two, let the oil and gas people go their own way, let the real estate people go their own way. And so that's what you deal with most of the time with, lots and blocks. Now in rural areas, it's not uncommon at all for people to really consider the mineral rights when they buy or sell land, and
Sure.
so they're much more generally considerate of the value of mineral rights, and that's partly because on bigger tracts, let's say you own 40 or 160 acres, those mineral rights are going to be much more valuable because When, again, we're talking about a square mile, which is 640 acres, if you've got 40 acres of that, that's a big chunk of that pie. So that all of a sudden becomes a much more valuable piece of, of property than the oil and gas rights to that. Whereas if you own, a tenth of an acre lot in a city, that's a tenth of an acre out of 640 acres, and that's much less. Not to say it's not valuable, but it's. I think some people would feel that it's not worth their time necessarily.
Mm-hmm. And it sounds like the process that you all go through to find out who actually owns the rights to the minerals is a lot similar to the way a title company goes through the process to find out who actually owns the house.
It's very similar. The rules are basically the same. We're all governed by the Oklahoma Title Examination Standards. So the rules are basically the same. There's a little bit of a different process. If you own a house in Oklahoma, you even if you don't know you own it, it may be on storage with a file company, but you've got an abstract of title that's, document maybe, 1, 2, 3 inches thick that tells you, every conveyance of that property from inception of title, when the government patented that out to present day. And then you have a title examiner that goes through that to determine that you own title when you buy that piece of property. There's no when you get a warranty deed, it's not like a car. You don't get a certificate of title that guarantees you own this. When you get a warranty deed, all you're really getting is whatever the person owns, plus their promise that if they don't own it, they'll make it right by you.
Sure.
But to actually determine that you own the property with very little chance of somebody else claiming a right to that property, that's the process of title examination and determining that everywhere along that chain, it's been handed off in such a way that now you have it with very little risk of anyone coming back and saying they own it.
Sure.
We do the same thing. We don't go off of abstracts because an abstract for a square mile of land, including all the oil and gas leases, reservations, mineral deeds that might have been left out of an abstract of title that a surface title company uses, it could be 1, 2, 3 boxes of documents as opposed to, a fairly concise abstract.
Okay.
So it's a little bit of a different process, but it's the same basic process overall. We're looking to see that chain of title from beginning to present day and tell you how to go fix that and make sure that you don't have any risk of being sued, someone else claiming property.
Right. So how long does that process typically take? Say I bring you 640 acres and I say, hey, do I own the mineral rights to this? And you run your survey.
Depending on the complexity, it could be days or it could be weeks.
Okay. Wow, that's fast.
Well, I say that's how long the process takes. Typically, we're busy in Oklahoma. We might have a backlog. We might, 60 to 90 days if we've got kind of a backlog going, but 30 days if we're kind of keeping up with work. So that's how long, typically it takes to get, in and out of the office. That may not be, we're not billing 90 days worth of time on your project, but
sure.
You're looking at usually days to weeks to get a billable time to actually get the product.
Okay. So say I have a house where we have mineral rights, and those they're actively drilling in that area, and I want to sell the house. What process do I go through to keep the mineral rights? And to make sure that I get to keep the mineral rights as I'm selling the house?
Well, the general rule is that if you sell your property and you don't reserve the minerals, they go with the property. So that's a really important thing to think about. It's not separate. If you own mineral rights, it's considered one with the land. Property lawyers like to talk a lot about bundles of sticks. What you get when you buy a piece of property is all these different rights. And so those oil and gas rights are one of those rights that comes with that property. but you can pull that particular stick out and keep it for yourself, and so really it's an active process to reserve the minerals, whereas it's a passive process to pass the minerals to your buyer. So what you're going to want to do is you're going to want to insert some sort of reservation language directly below the legal description in your deed that just says that the grantor reserves all oil, gas, and other minerals in the property. And that brings me to something else that I wanted to talk about, which is mostly what I'm talking about is oil and gas rights. Oklahoma, of course, there are all kinds of minerals in land, and people kind of think about minerals different ways. Well, does that include gold? Does that include gravel? Does that include coal? Of course, we don't have a lot of gold. Coal's not necessarily a valuable mineral in Oklahoma, but there is some coal mining in the eastern part of the state. And then, of course, gravel is something different. But typically, when we talk about mineral rights, we're talking about oil and gas rights. If you want to reserve coal rights, assuming that you still own those, you have to insert a separate reservation of coal rights, or reserve all interest in coal.
So you have to be specific about the mineral.
Yeah. When you say oil, gas, and other minerals, that gets you oil, gas, and minerals like oil and gas. So it's limited by that language. So that doesn't get you all minerals. That just gets you hydrocarbons, what we think of as oil and natural gas. If you want to reserve anything else, gravel is a good example. Gravel always goes with the surface. It's basically not considered a mineral generally. Gravel will go with the surface. So if you wanted to reserve that, you would have to set that up as a separate sort of reservation. But yeah, generally speaking, oil and gas is what is valuable in Oklahoma. That's what people reserve, and that's what people convey. So you want to set that up as a reservation directly under the legal description in your property. You'll see a lot of times in deeds it'll say kind of below that, where you've got all that warranty language right before the signature, less than accept oil, gas, and other minerals. That's really designed as an exception to the warranty. That's saying I don't really know who owns the oil, gas, and mineral rights, but I'm not going to warrant title to those, but you put it above there, and that actually is going to reserve it to you.
Sure. So tell me, now that we know kind of how to make sure that we get to keep the mineral rights, before I think we even decide to keep it, we'd want to know, how much it's worth.
Yeah.
And so give us an idea of, how you could potentially calculate the value of mineral rights.
That's a tough question, and I'll start off by saying that you probably would want to talk to your neighbors, find out kind of if they've dealt with, oil and gas lessees, oil and gas companies coming in to lease their rights, how much they're being paid, or to purchase their minerals, how much they've been offered for those. So like anything, it's a market-based transaction. I will say that what we've used at this office as a rule of thumb in the past, and it's probably a good starting point for negotiation, but not necessarily determinative, would be about 16 months of production. If you've got a producing well on that land, then you can take your statement, multiply this month's revenue times 60, and that'll get you about a good starting point to determine what your minerals are worth. And then if somebody offers you way less than that, that's probably not a fair offer. If somebody offers you way more than that, then you may want to jump on that. So that's probably a good starting point. It's about 60 months of production.
Okay. All right. And one of the final questions that I had is really just to clear up what goes through somebody's mind whenever they receive one of those pieces of paper in the mail that gives them 3 options that they can pick from.
Okay.
Can you talk about, and I know we don't have that specifically here with us, but can you talk about those options that they typically send out with that paperwork and kind of what the pros and cons are of those?
Well, there's probably, if you're a mineral owner and you're not expecting this, or you're not familiar with the process, then you may get a number of different things in the mail. You may get an offer to purchase your minerals. You may get an offer to lease your minerals, and those are two separate transactions. And then you also might get what's called a notice of forced pooling or a notice of statutory pooling. And that's the third one there is what you're talking about, I think. And that's basically saying that an oil and gas company wants to drill a well around your house, in what's called a pooled unit, basically. They're going to include your tract of land in their overall oil and gas production. And so that forced pooling, it's a little bit like a forced lease. It basically, well, I want to go back and talk about what an oil and gas lease does first, to talk about that, and then kind of get into pooling. But you can either sell your minerals, and that's through a mineral deed or a conveyance, or you can lease them. And a lease is for something less than perpetuity. So a lease is when you get that document in the mail, and it's usually in the form of an offer from an oil and gas company, that it'll say oil and gas lease on top. And one of the things you'll notice is it's got a term in there that says for 3 years and as long thereafter as oil and gas is produced. Or the term could vary. It could be 5 years, it could be 2 years. But basically what that's saying is that you're giving up your right to drill your own well, which most people are not in a position to do, to an oil and gas company to come in and drill a well on your property or on property near your property that's been included in this unit. The oil and gas company has that term, that 3 years, it's pretty typical, to drill a well or they lose that lease. Now, if they drill a well during that time and that well ends up producing commercially or being capable of producing oil and gas, then that lease is held for as long thereafter as oil and gas is produced or capable of being produced. And so, what we're talking about when we go back and talk about forced pooling, which is that letter you get in the mail that's got multiple options, is in theory the companies are supposed to offer you a lease first. Sometimes they don't do great due diligence, and that may be the first you hear from them, is getting that notice of pooling. But basically it acts like a forced lease. You have an option to either participate in the well, which means you pay a cost associated with drilling and completing that well, and then you get whatever your share of production is out of that well. So that's your first option. And then similar to an oil and gas lease, your second option is going to be, second, third, fourth option, whatever it may be, is going to be to accept a royalty, which is a cost-free portion of production, and a bonus, which is an upfront payment, and then you give your right up to drill to the oil and gas company, which means you don't have to pay any cost. You just get that share. You get that share of production, that royalty, free of any cost. So those are your options under that. But basically, it acts like a quasi-judicial taking of your property. Sure. You do get paid for it. That's what that notice is. It's due process requires two things. It requires a notice of pending litigation against you, and it requires an opportunity to be heard. So in theory, you can go to the hearing, you can protest the oil and gas case, you can protest the terms under which they're going to offer you a royalty and that sort of thing. And then eventually the Oklahoma Corporation Commission will enter an order pooling that property, and then you'll make an election based on that.
Okay, interesting. Well, so now there was one thing that we didn't cover that I want to make sure to cover in this video is, so you sell the land, you want to keep the house, but you're selling the mineral rights to somebody, or maybe you want to sell the house and the mineral rights, and this person is already participating in an act of drilling. So how does the new owner, how do they approach the oil company that they're participating with, that the previous owner was participating with, and switch that over? How do they go through that?
Okay, that's a great question. Because the oil company is not necessarily going to be on notice that this interest was sold. And so typically you're going to have to take some, if you're the buyer of that right to participate, or even the buyer of a royalty interest under an oil and gas lease, you bought the minerals, but they're currently under lease, then you need to take some action to notify the oil and gas company that you are the new owner and that any interest attributed to the prior owner should be now paid toward you. Or if you're participating, which again is you didn't lease the interest, you agreed to participate in the well, then any bills for any joint interest billings, is what they're called, be forwarded to you, and then also any your kind of production, your revenue.
Okay.
So
who's typically the person that you reach out to within the company?
Well, you're going to have to find out what the company is first.
Okay.
So that's part of the issue, and you may need to go find a copy of your oil and gas lease, or find out the operator of the well through the corporation commission would be a good starting place for that.
Okay.
Just say know your legal description, where you're at, and tell them there's this producing well. I want to know who the operator is. And then once you have that operator information, you're going to want to, search them online or however you come up with that. And then you're going to want to contact their division order department. That's the department that deals with revenue, basically, paying out revenue. And they'll probably ask for a copy of your deed. You mail them a copy of your deed, and then they'll put you into their system as the present owner.
Awesome. Okay. Well, that's all the questions that I had prepared for you today. If you've got any last words, go ahead and throw it out there. We also want to know, we want to hear again, who you are and the best way to get in touch with you if we've got any questions related to this.
Okay, the best way to get in touch, Elias Books Brown and Nelson is the firm. You can Google us. The website is Elias Books. That's ELIASBOOKS.com. I'm on the website. You can find our contact information there. We're glad to help. We do a lot of, again, we represent a lot of operators, so that limits us in what we can do in terms of litigation, but we can definitely do probates that need to be done on mineral interests or on surface interests. We can do mineral deeds and conveyances between families and things like that. That's kind of typically a lot of what we do for buyers and sellers, those sorts of parties. Again, I'm Frank Hinton. You can find me on the website. I'm sure my information will be, on the Facebook page and everything else. So, feel free to contact me.
Absolutely. Well, man, I appreciate you taking
Thanks,
some time
James.
with us today.
I appreciate the opportunity.
And for you all, if you've got any questions related to this interview between me and Frank, be sure and post them in the comments below, and we'll get those questions answered for you. So that's what this is all about. I learned a lot through this process, working through this particular property with Frank, and so I wanted to get on here and share some of that with y'all. So that concludes this video, and we will see you next time.